Hi, good afternoon, everybody. Thanks for joining us. We're going to get started with today's webinar, Navigating SBA's Present Effect on Your Corporate Strategies. My name is John Williams. I'm a partner here at PilieroMazza, and I'm very happy to be joined today by my colleague, Kimi Murakami, who is a counsel in our corporate group. And Kimi and I have done several webinars together in the past. Hopefully you've been able to participate in some of them because there's a lot of good symmetries between our practice groups here at the firm. I'm in the government contracts group, so I handle on a day-to-day basis pretty much everything that you might encounter when you're doing business with the federal government. And in particular, I work a lot with the small business procurement program, so both small and large firms who are participating in or partnering in the small business procurement programs. And Kimi's in our corporate group, so she does a lot of mergers and acquisitions, a lot of internal corporate strategies and plans, etc. And when you're doing those types of things for government contractors, then you have to be mindful of the regulatory requirements and sort of the rules of the road when you work with the federal government, and especially in the small business programs, because when you're doing a merger or an acquisition, or you're doing an internal restructuring, or any of the other strategies that Kimi might work with our companies to employ, they might be impacted by the small business regulations. If you're participating in the SDVOSB program or the Hub Zone program or 8A, you have to be mindful of the unique rules that those programs have for ownership and control of the businesses. So it's a good chance for us today to talk through an issue that affects both my practice in the government contracts group and Kimi's practice in the business and corporate group, this SBA present effect rule. It's one of SBA's affiliation rules. So if you're in any of the small business programs, you should know the concept of affiliation. It's really critical. We're just going to focus on the present effect rule today. There are a lot of different types of affiliation, and I'll start off by giving a little bit of an overview on affiliation and why you should know about that when you participate in these programs. And then I'll drill down on the subject of today's webinar, the present effect rule. And when I'm done setting the stage, I'm going to turn it over to Kimi, and she's going to talk through some of the corporate strategies that her group employs for our clients, and then we'll talk through, how are those strategies, if you're considering a merger or acquisition, or if you're considering giving somebody a stock option, how do you have to think about those strategies in light of the present effect rule? Because the present effect rule is maybe one of the lesser known affiliation rules, but it can definitely have a big impact on these corporate strategies. So our hope is that we'll leave you guys with some good takeaways on things to make sure you have in mind when you're considering these corporate strategies under the present effect rule. We'll make all of these slides available to you after the webinar is over. You'll get an email, so be sure to look for that. And don't be shy about asking questions throughout the webinar. Go ahead and use the chat box. Kimi and I will answer as many as we can during the webinar, and if there's any that we can't get to during the webinar, we will follow up with you by email afterwards. So please go ahead and fire away. We answer them all anonymously during the webinar, so you don't have to worry about outing yourself, so to speak. Just go ahead and type them away, and we'll do our best to answer them all during the webinar. Okay, so without further ado, let's set the stage for why we're going to talk about the present effect rule, and why do you care about that when you're working with Kimi to put these corporate strategies in place? Well, because your size matters. If you're a federal contractor participating in any of the set-aside programs, or if you're a large business that is partnering with a small business in any of these set-aside programs, small business status is the #1 eligibility requirement. You got to be small to be in the small business programs. Goes without saying. So, being a small business also exempts you from certain other requirements, such as reporting exec comp and having a code of ethics and cost accounting standards. So there are additional advantages for being a federal contractor if you qualify as a small business. There are also some potential liabilities associated specifically with representing yourself as a small business if you are not, in fact, a small business. So it's very important because of that to be sure that if you're signing on the dotted line, so to speak, and saying I'm a small business, or making that representation in sam.gov, you want to be sure that it's an accurate representation. So you want to be mindful of the ways in which affiliation can impact your small business status, because you want to be sure you're small, and affiliation can definitely have an impact on your small business status. So just as a basic point here, establishing that your small business status is going to be determined by either your revenues or your employees. Depends on the industry code, the NAICS code that applies to your contract or to your primary industry. And the calculations are listed here in the first few bullets. It's going to be 3 most recently completed fiscal years if it's a revenue size standard, or each pay period, the average of each pay period during the past 12 months, if it's an employee-based size standard. So if SBA was conducting a size determination of your firm, they would look at your tax returns or your payroll reports to determine first and foremost, are you a small business under your size standard? So let's say you're in the IT field, and many of the firms in the IT field have a $27.5 million size standard for the industry that they play in. So we're going to look at your tax returns to see in the most recent 3 years, is the average of your revenues below $27.5 million? If it is, great. You're small, at least by yourself, you're a small business. But if you have an affiliate, then your affiliate's annual revenues, or in the case of an employee-based industry, your affiliate's employees, are going to be counted with your revenues or your employees to determine if you're a small business. So you can see then how having an affiliation can have a real direct impact on your small business status, because I might look at your tax returns and see that you're at 20 million average against a $27.5 million size standard. But if you have 2 affiliates that combined have $10 million in average annual revenue, that means that in SBA's eyes, you're really a $30 million business, in which case you're not small. So that's an example of how affiliation can wreck your small business status, even though that you may be small on your own. So affiliation, I said before, there's a lot of different ways you can become affiliated. It's really ultimately about control. So SBA is going to look at whether one business or one individual has the power to control another. That's really the bottom line analysis for affiliation is control. Control can be either affirmative or negative. And I think Kimmy will talk a little bit about negative control, which is something that comes up a lot in the corporate context. What we mean by negative control is that somebody has the right, or a company has the right to block the majority from acting, or block a company from doing something. So it's like a veto right, or a unanimity requirement, that if, let's say I'm the majority owner and Kimmy's the minority owner of the business, if I can't take certain actions on behalf of the company without Kimmy approving, she has negative control over those decisions. She can't affirmatively control them on her own, but she can block me from doing with them if she doesn't agree with them. So that's negative control, and that comes up a lot in the corporate world, and the strategies that we want to employ. So any type of business can be an affiliate, including a nonprofit. And an important point for as we get later into the presentation, when there's a protest filed, or when SBA is going to decide your size status, they're going to judge it at a very specific point in time. And usually that's the date that you submit your proposal with price, your initial proposal with price. So when we care about the existence of affiliation is the date of your initial proposal with price. We're looking at the circumstances that existed as of the date of your initial proposal was submitted with price. So, something that might happen after the proposal goes in most likely is not going to affect the affiliation analysis. We're going to be looking at the circumstances that existed on that date of initial proposal submission with price. Next slide popping up here gives you just a very quick overview of the different types of affiliation. This is from the SBA's regulations. We've done some webinars in the past on these other types of affiliation here. So if anybody has specific questions or would like more information about affiliation through stock ownership or ostensible subcontractor or identity of interest, feel free to reach out to us, and we can either link you to prior webinars, or Kimmy and I can just quickly walk you through it, because I'm not going to go into detail on each of these different types of affiliation. The one that's highlighted in red, affiliation through stock options, convertible securities, and merger agreements, that's what we're going to focus on today. And that is the SBA's so-called present effect rule. So this rule says that SBA will consider stock options, convertible securities, and agreements to merge, including agreements in principle. And we're going to come back to that. What is an agreement in principle? Kimmy's going to talk about that. But for now, let's just start off by understanding what the rule says. And this rule says that the SBA will consider stock options, convertible securities, and agreements to merge, including agreements in principle, to have a present effect on the power to control a concern. All right, so in plain English, present effect means that the SBA will treat that stock option or the convertible security or the agreement in principle as though the rights granted have already been exercised. So it might seem not intuitive that you have a stock option. I don't actually have the stock yet. I just have the option to get the stock. But yet SBA might look at that stock option and treat you as if you're already the holder of the stock, the owner of the stock, even though you haven't exercised the option yet, because they will give that option, quote, present effect. So, and this next slide provides a little drill down on how present effect can cause issues for small business status. So, and as I turn it over to Kimmy here in just a few moments, you'll get a clearer picture when you're doing these corporate strategies. If you bring on a new owner, that owner could have other ownership interests, right? Or it could be another company, and that the new owner could be a company, and the company could be a large business or have many other holdings. And so if SBA gives present effect to an agreement to merge with that other company, or stock options that you might give to, Bill Gates or somebody who has a lot of other interests and that could impact the size of your company, that can create an issue for your small business status. So here's an example. Because I think it might be easier to understand as we walk through this example. So let's say your business is 100% owned by a service-disabled veteran, so it qualifies as an SDVOSB. But then the business gives stock options, or it enters into an agreement in principle to sell 51% of the business to a large company. So it hasn't actually given away the 51% interest. It has just entered into either an agreement in principle, like an early stages agreement, or maybe given away stock options where someone else is going to become the 51% owner of the business. Hasn't happened yet, but it's an option that it could happen in the future. If SBA gives present effect to the stock option or the agreement in principle, that company is no longer 100% owned by a service-disabled veteran, even though that stock option hasn't been exercised yet or the agreement in principle to sell the company, the deal hasn't closed yet. and may not close for a while. And that's what's really, again, I think counterintuitive and frankly a little bit crazy about this rule, that we're going to say an agreement in principle to sell 51%, even if you haven't actually closed the transaction and you may not close it for a while in the future, can be treated as if it's already happened. And so, as a result, in this example, the company would no longer be SDVOSB because they've given present effect to the transaction that would result in someone else being the 51% owner. So there are exceptions to the present effect rule, and I see, a question has come in, is it optional to apply present effect? It's not optional from the standpoint that SBA can decide to do it or not do it on a whim, but the rule either applies or it doesn't. SBA either gives present effect or it shouldn't give present effect, and that depends on what we're seeing on slide 11 here on your screen. SBA will not give present effect to agreements to open or continue negotiations towards the possibility of a merger or sale of stock at some later date. So, okay, if we want to step outside and take a walk with me for a moment, and let's talk about what is an agreement to open or continue negotiations versus an agreement in principle. I mean, now we're really getting into some gray, esoteric areas, I think. Hard for the contractor community to really know where the line is drawn, I think, on what is an agreement to open or continue negotiations towards the possibility of a merger versus an agreement in principle for a merger or sale of stock. If it's an agreement to open or continue negotiations, the SBA will not give it present effect. If it's an agreement in principle, they will give it a present effect. And we'll drill down a little bit as we move forward on, as best we can, how can we put some lines around when do you reach an agreement in principle? If there is nothing black and white in the rule, unfortunately, that tells us what is an agreement to open or continue negotiations versus an agreement in principle. So we have to rely somewhat on case law, the tough breaks that other companies have gone through when they've litigated this issue, to see how those terms are defined. But I just, suffice it to say at this point, there's gray area there. The SBA also will not give present effect or should not give present effect when the trigger point for the stock option or the convertible security or the agreement is too speculative, or it's incapable of fulfillment, or it's unenforceable under state law, that is extremely remote. And again, we're going to put some more real-world context on this as we move along. I'm just setting the foundation right now for what the rule actually says, and then we're going to give you some real-world examples of, well, what is an option that's extremely remote that SBA wouldn't give present effect to versus an option that they would give present effect to. And there was a case a little while ago that SBA's Office of Hearings and Appeals, that's the appellate authority for SBA cases. They have administrative law judges at SBA that hear appeals from protest decisions and other types of cases. And somebody was arguing that there had been an agreement in principle to revise an operating agreement. And so, the argument was you should treat the agreement in principle, you should give it present effect, and therefore treat the operating agreement as if it had already been revised. And the Office of Hearings and Appeals judge said, we don't give present effect to agreements in principle to revise an operating agreement. The present effect rule only applies to the types of agreements that are specifically mentioned in the rule. So that's stock options, convertible securities, and agreements to merge or for the sale of stock. So you couldn't argue, you couldn't have, this promise or agreement in principle to make a revision to your operating agreement or something like that. They would not give present effect to that. And I keep saying SBA would give present effect, so I just want to underscore the point on this next slide that only SBA can give present effect. You can't give present effect. People have tried this many times where they say, well, look, let's say a large business currently controls the company, because let's say maybe they have 100% of the stock. It's a wholly owned subsidiary of a large business. But there is an agreement in principle to sell 51% of that subsidiary to John Doe. And so the large business argues, well, no, the subsidiary is not large because we have an agreement in principle to sell it to John Doe. So John Doe, you should treat John Doe as the one controlling the subsidiary. And SBA they don't allow that. They don't let you use present effect to undo control by a large business. That they're going to consider the large business to control that subsidiary until they've actually divested their control of the subsidiary. It only works the other way, where SBA can give present effect. So essentially, they won't let you use it on offense. They're only going to use it against you, and that's just the way it goes. All right, last point I'm going to make before turning it over to Kimmy is that what I've been talking about is affiliation. Present effect can lead to affiliation, and that's a concept in SBA's small business regulations. So when we talk about affiliation, what we're talking about is the potential impact on your small business status, how SBA determines size. There is a comparable rule for 8A eligibility. The SBA also has rules for 8A. They run the 8A program, and they have this regulation that says that essentially it's not exactly a present effect rule, but the concept is similar, that if you have an agreement in principle to change the ownership in an 8A business, you have to go to SBA first. You can't just go ahead and reach that agreement in principle, even though you haven't actually finalized the deal. Again, this is the sort of the counterintuitive point I'm going to keep harping on. Even though you haven't actually closed the transaction and changed ownership, just having an agreement in principle could be enough to create a problem, both from your small business status under the present effect rule, and also if you happen to be an 8A company. I just want you to be mindful of that as well, because it can lead to a suspension or termination from the 8A program. And as I'm turning it over to Kimmy here, I see we've gotten a question about letters of intent. So that's a fantastic question. It's a perfect segue into Kimmy. The question is, under what circumstances would an executed letter of intent to merge be considered an agreement in principle? We're going to spend a good amount of time on that, so just sit back and we'll get to that shortly.
Great, thank you, John. And I also just want to point out about that last regulation we were looking at, that's a distinction there which goes to that first question John covered, which is that under that 8A eligibility, if you have an agreement in principle, you have to notify the SBA. Again, here when we're talking about the present effect rule, we're talking about something that might be applied to you, but you haven't had to go take any particular action to notify the SBA that you have given stock options or that you're entering into a letter of intent. So let's just drill down a little bit more on the three types of agreements that come into play with the present effect rule. And those are, as we've been talking about, the stock options, an agreement to merge, and convertible securities. So a stock option is a right that's given to a key employee or certain executives or investors or even another company. And when you're given that right, it's an option that you have to, at a later point in time, to exercise your option, or in other words, to then buy the shares of stock. So when you're given the option, you don't have any true equity yet. You just have a right to exercise that and buy equity in the future. When you buy that equity ownership, hopefully the value has gone up. You hold that option for a certain amount of time so that your options have vested. You're then allowed to exercise them, buy the true equity ownership. If the stock price or the value has gone up, you're going to sell them. Oftentimes this happens almost as one fluid transaction, so that you sell you buy your shares, you've exercised your options, you now have equity ownership, and then you sell it right away at a better price, and then you net the difference of that. So here, what I've explained to you in the under corporate law is a right that you have for something in the future. It's not going to take place. You're not going to have true equity until one of these triggers has happened. When you're granted your options, it might be something that is within your discretion after you have vested options. It might not happen until your death or you become disabled. It might not happen, or you might not be able to exercise your option until there's a sale event of your company. Or maybe if there are certain benchmarks or milestones that will be hit by the company. So again, this is a conditional future right that you might have. Now, having said all that, notwithstanding the fact that I'm telling you under corporate law you don't have true equity ownership yet, under the present effect rule, which we're talking about, the SBA is going to give those stock options present effect and treat them as if they've already been exercised on the date that those stock options were granted to you. So this is why it's a very unique, kind of interesting rule. When I, as a corporate lawyer, came in and found out about this, it was kind of counter to what I actually thought. But yes, it is actual that the SBA is going to go ahead and act as if those options have already been exercised, even though they haven't vested yet, even though you haven't exercised them yet. So you have to kind of look at this, and it's very fact determinative of when will the SBA apply the present effect rule. So that's what we're going to talk about in each of these three scenarios. And again, as John was describing, this is why we look at these OHA cases as they come out and try and come up with the parameters or the certain facts where we can advise you as to whether or not the present effect rule will be applied. So in the case of stock options, some of the questions to ask yourself about the stock options you're granting, for example, is there a complete agreement? Or is it difficult to determine when you can exercise your options? Again, this goes to the part of the rule that talks about whether or not it's remote or it's too speculative. You need to also ask whether or not it's difficult to determine the amount of shares or that you'll be able to exercise or to buy later on. And is the option tied to an undetermined point in time in the future? Or is it something that you can determine? One case, for example, had to do with terrible financial conditions of a company. Well, that's something that's very speculative, very difficult to determine when that would be. And in that case, for example, the SBA did not apply the present effect rule.
Yeah, most of these questions here really emanate from cases. These aren't, clear guideposts in the regulation itself. It's what I read to you before is all the regulation actually says. So, we look at prior SBA cases to try to flesh out, well, when will they or won't they treat a stock option, give it present effect? When is it considered to be too remote? And Kimmy mentioned there was a case where the option was tied to a decline. Was it in the revenues or the enterprise value of the business by 20 million or something like that? And that was just too speculative or remote to give present effect. There was another one where there was a complicated formula that was based on the financial performance of the business that would have to be used to determine the amount of shares that the person would be entitled to when they exercise their option. That was considered to be too remote or too speculative. But on the other hand, if it's really easy to exercise, then it's very likely to get present effect.
Right. So we also just want to, in this slide, kind of propose like a few workarounds. I mean, giving stock options creates great incentives for your employees and great reward for key management executives. So we wanted to provide some workarounds or alternatives for stock options. For example, perhaps consider giving stock options in a different class of stock or non-voting stock. The reason we're raising this one is because affiliation, as John was describing, is all about control based upon voting stock, like in the example of negative control. But when we raise this as maybe something to consider, we also have to keep in mind, for example, many of you are S corporations, and if an S corp, you can't have different classes of stock. Or also, as small business government contractors, under some of the regulations, for example, with the SBAs, there has to be direct majority ownership of every class of stock. So again, this is one way that maybe we could make this work if you wanted to give stock options. But again, we're always trying to keep in mind what are the other regulatory restrictions that we have to make sure that we keep with them, whether they're by the IRS for S corporations or whether or not it's SBA rules because you're an SDVOSB. Another workaround for stock options is, let's just think of another way to award or create incentives for key employees, such as just giving cash bonuses, or maybe just not giving true ownership, which again in this regulatory regime can kind of trip us up. So instead, let's look at something like what we call quasi-equity here. And that has to do with things such as stock appreciation rights or putting in place a phantom stock plan. And in these cases, those are more like contract rights, if you will. They do use like stock as the metric or the unit of measurement for determining how much reward you might get as a bonus, but they're not true equity. True equity or true ownership of a company includes voting rights. There are reporting requirements that you get if you're a true owner of a company. But in these cases, using quasi-equity, this is something else that sometimes we put in place for clients when they do want to have something that's like a stock option, if you will, to reward the employees or create an incentive there. But again, it doesn't trip up something like the present effect rule, for example.
So, Kimmy, we got a question here. Would phantom stock be considered a trigger event once financial milestones are met? So I guess the questioner's idea is that we'll have some type of financial milestone, and if the company meets that milestone, it would trigger an award of phantom stock. So I think you've basically just addressed this, but why don't you just underscore that?
Sure. So yes, depending on the kind of plan that you put in place, if, for example, we have an employee whose award, they're part of this plan, they're participating in the plan, and they've been told that if, for example, revenues reach a certain level because of certain contracts or something that might come in, and if at a particular time as laid out in the plan that has happened, then perhaps that employee is going to get, if it was like an appreciation right, for example, the difference between what the value was of the share at the time they were given that right versus now having hit that milestone and what the value has increased, then they're going to get the difference of that. So yes, that's why I was saying it's more like a contract right. It's not like they have true ownership in the company. They're just getting awarded based upon using that unit of measurement of like a stock unit.
But and I guess an additional point on that, why this is a workaround is that if you had a trigger point, an option that resulted in the award of phantom stock or participation in a stock appreciation rights plan, that shouldn't affect your small business status because, like Kimmy said, the whole idea behind calling this phantom stock as opposed to actual stock is that it doesn't include typical rights of actual stock like voting. And when we're concerned about control, remember I said at the outset, affiliation is all about control, right? So we're looking at whether if we give present effect to a stock option, do we have a new controlling owner? That's really our issue. You know, the example I gave earlier was about an SDVOSB that gave a stock option for 51% to a non-SDVOSB. So in that scenario, we'd have a new controlling owner and the company would lose SDVOSB status. So if we have a stock option that's actually a phantom stock option, then they're not getting actual voting ownership, and that's what we care about, is actual voting ownership. I mean, at least from a size standpoint, when you participate in some of these other programs like SDVOSB or woman-owned 8A, we do also care about non-voting stock. The rules expect that the woman or the SDVOSB is going to have a majority of all classes of ownership. So giving away phantom stock needs to be done carefully. It's also an accounting issue too. So I think this is a very popular project for our corporate group. I think these incentives for key employees, because you don't oftentimes want to give away actual ownership. And it helps you get around some issues, like if you're in a program that would require a notification when you have an ownership change. I don't think you need to notify on an ownership change when all you've done is give away phantom stock, because that's not actual ownership, in my view. But that doesn't mean you can just go ahead and give it away. I mean, you want to consider the potential impacts, especially if you're in some of the socioeconomic programs. But it is an elegant way to solve the present effect and some of these other issues, as Kimmy was describing.
Okay, so let's move on to the second scenario we were going to talk about, as described in the present effect rule, which are agreements to merge, or later on then in the rule it says sale of stock. So agreements, what we're referring to here as agreements to acquire. And this is really commonly how this comes up most in my practice, is when a small business government contractor is thinking about entering into a transaction, a merger or acquisition transaction. So these next couple of slides are just going to kind of lay the foundation so that I make sure we're kind of all thinking about the same thing and what I'm describing to then apply the present effect rule. So an agreement to acquire is commonly like an asset purchase, for example, where you want to buy government contracts. And as you all know, we can't just buy a single government contract, but all the assets necessary for performance of that contract. So when we structure a transaction as an asset purchase, we have an asset purchase agreement. We're going to have to go through the novation process after it closes. And that's what we're talking about here. And I'm going to get to the point of describing how the letter of intent comes into play here and the application of the present effect rule. Another way to structure a transaction is as a stock purchase transaction, and that's where you're buying all of the equity of another company, another contractor, for example, and this is structured as a stock purchase transaction. Generally, under the FAR, novation is not going to be required if you do a stock purchase transaction, but there are other issues involved with that, involving like all the liabilities. You're getting the good and the bad if you're doing a stock purchase and actually acquiring a company. The third kind of scenario we're going to be talking about here is an agreement to merge. Merger is something that's laid out in each of the state corporate laws, and it's where you have one company that actually like swallows or is merged with and into another company. And it effectuates that the non-surviving company is gone. It's dissolved. It no longer exists. So in my practice, at least, for government contractors, if the non-surviving company, because it can go in both directions, if the non-surviving company is the initial contract holder, and once the merger takes place and you filed all those documents, then that original contract holder is no longer going to exist, it makes doing the novation, and novation is triggered with merger, it makes doing the novation very, very challenging. So Often I don't have a lot of mergers. We do a lot, though, of asset purchase transactions. But again, the regulation, particularly for the present effect rule, talks in terms of agreements to merge. So I just wanted to make sure we're all clear on the kinds of transactions I'm describing here. So when you're doing like an M&A transaction, this is just a visual for you to kind of understand the different steps in a transaction. And again, I'm covering this because we're going to get into the letter of intent. So in the very beginning of a transaction, when a buyer and seller first start talking to each other, you're going to have an NDA in place so that there's confidentiality about the information that's being disclosed by both parties. And you might enter into a letter of intent. And a letter of intent is kind of the terms, the key terms. And so this is happening really at the very beginning of a transaction. The parties will then, of course, kind of almost simultaneously with that first stage be talking about whether or not they're going to structure this as an asset purchase, stock purchase, or maybe a merger. And after that, you'll get into some due diligence where you're really looking under the hood, kind of kicking the tires, looking at the company, looking at the contracts, the backlog, what they have in their pipeline. And all of that. And then the lawyers at that point are starting to paper the deal or doing the document drafting, there are negotiations going on, and then hopefully everything will go smoothly. You'll end up at a closing, and after the transaction is closed, you'll be submitting a novation package if required. You're going to be addressing recertification issues as to your size or your status, perhaps. And then there might also be notifications that have to be given with a certain amount of time to the contracting officers. So the reason I'm going through all these different steps here is because then that kind of sets the stage for why, with the present effect rule, letters of intent are very, very important. And, you know, for those who maybe just have done mergers and acquisitions, but not in the government contracts setting and not in the small business government contract setting, you wouldn't even think that the LOI is going to be a problem, if you will, if you didn't know about the present effect rule, because LOIs are very common in structuring a merger and acquisition transaction. Because the LOI really sets forth the roadmap or the deal terms, and the parties, when they get together, they're really excited. They're want to do a deal together, and so having an LOI or kind of a game plan of how you're going to structure a transaction that the parties are going to sign really makes you feel like, okay, we're going to get a deal done here. So it's very, very common, and generally in a letter of intent, you're going to state that it's non-binding, that this is really kind of a proposed transaction. And you might, you know, say in your LOI, like these paragraphs are non-binding, where I talk about what the price might be, where we talk about how we think we're going to structure the transaction. There will be, in these other paragraphs, certain terms that are going to be binding, such as maintaining confidentiality. If you're the buyer party, you're going to want to have exclusivity imposed on the seller so that you don't have a seller who's going to be getting to talk to other people. You want that seller to be exclusive to you, the buyer, because you really want to do this deal with them. You're going to want it to be binding that the seller is going to maintain and continue operations and conduct itself the way it has been. You don't want them to go sell certain other assets or get rid of certain things or conduct itself in a way that when you finally get to closing, it's not the business that you thought you were going to be buying or the assets you thought you were going to be acquiring. You want to also have access to the seller so that you can go in there and do your due diligence. And then also there might be conditions subject to getting your financing, if possible, if applicable in a particular deal. So do you then have the key issue here when we're talking about the present effect rule is, do you have an LOI that is an agreement in principle? And how are we going to know that? And this is where, like looking at the OHA cases and the SBA's interpretation, we can kind of get some fences or guideposts as to whether or not an LOI rises to being an agreement in principle. And if so, then the SBA is going to impose or apply the present effect rule. And then we're going to have affiliation, and then we have problems with our, making sure that we still haven't blown through our size. So some of the questions in looking at the OHA cases that we've laid out for here, some of the questions that you have to consider is, like, in looking at your LOI, when is your deal actually going to close? Like, have you done an LOI that's so certain, if you will, that you're able to close next week? Well, then that probably weighs in favor of having an agreement in principle, and the SBA is going to say, hey, the present effect rule is going to apply. Was your LOI so specific as to how much you're going to pay if you're the buyer, how much your purchase price was? Or instead, were you more in a range? I'm going to pay you something between this and that. Because if you use a range, then that's less of a firm, definitive offer. It's more speculative. And if more speculative, then it weighs in favor of not applying the present effect rule. How much due diligence has been done and completed? Or how much have you said in your LOI that this is really conditional upon due diligence being completed? So again, like, these are not, like, having one of these is going to weigh in your favor of application or non-application of the present effect rule. We're kind of giving you a lot of different factors here that the SBA is going to take into consideration. So, like, having mere negotiations is not enough. Is there a formal document memorializing negotiations and next steps? Is the merger essentially done and signed up for?
Yeah, that point on the negotiations, that comes specifically from a case where the SBA did not give present effect, or shouldn't have given present effect, because there was no actual agreement, nothing in writing. There had just been negotiations. So the concept of present effect applies to a document. We're going to potentially treat an agreement in principle, but it wouldn't be an agreement in principle to oral negotiations. It would have to be that you've had negotiations and they were reduced to a writing, and then the question becomes, is that written document an agreement in principle?
And just like with the other factors, merger, for example, is it essentially done? Is the only thing left to do is to file the documents as required at the state level and get your shareholder approval? Or is there a lot more that it still needs to be completed? Again, just like in any case, it's very important just to keep these things in mind, that you don't have emails, for example, back and forth between the parties saying, great, we're almost done, our deal is almost completed, when what you have is just your letter of intent. Because if that's the case where you have emails like that, then again, that's evidence for the SBA that they should apply the present effect rule. And do the parties, the last one here that we've listed is, do the parties have big or easy ways to get out of the agreement so that it doesn't look like something that's really near completion, or weighs in favor of having an agreement in principle. So this is why LOIs can cause affiliation problems. It doesn't matter if in your LOI, for example, you've said it's non-binding. This is a non-binding LOI, or it's very conditional. Yes, it's important to use that language, but again, just saying that is not enough. So it's these facts that are going to weigh into the SBA's determination. So you, like I was saying before, you just want to make sure that you give more of a range of price, or you lay out the price. Maybe you've given I've seen LOIs done where you have 3 different prices given. I'm going to pay you this amount, and more upfront, for example, or a certain percentage in an earn-out. Give different kinds of options for how the price might be paid, and not one set price or one set term as to how that's going to be done. Merely agreeing to negotiate exclusively should not be a problem. We have exclusivity provisions all the time in our LOIs, but again, it's just we're trying to provide those kinds of factors which, when added all together, could lead to the SBA saying that there should be an agreement in principle and that the present effect rule is going to apply. Again, the timing, like we talked about before, there are cases where if you're going to close within a matter of weeks, less than a month, the LOI, that could be problematic. Whereas if the closing is going to take place for a substantial amount of time, then that's a factor that weighs less in favor of applying the present effect rule.
Yeah, and I have some firsthand experience with, frankly, just how crazy this rule is, because we had a case with a letter of intent that went to the Court of Federal Claims many years ago, and I mean, everything Kimmy just said is exactly what we argued about our letter of intent, that it all the way up and down the letter disclaimed how non-binding it was. And from a legal standpoint, neither party could have gone into court using that letter of intent to force the other party to close the deal. At that point in time, it was just a non-binding letter of intent. But unfortunately, the way, and some of this is on how it was written, but some of it was just on how the SBA, at least at that time, looked at it. Their view was the letter of intent reflected that the parties had already gotten very far out of the station in the process. They did not think there was that much left to be done to close the deal. And then the deal actually did close a couple months later, but it was after the proposal had been submitted on a very important small business contract. So I said at the outset, size is determined as of a particular point in time. It's the date you submit your proposal with price in most cases. And in most cases, SBA will not look at what happens after the proposal comes in. So you can't try to claim, oh, I fixed things to, I don't have this affiliation issue anymore, or I amended my tax returns, or no, if it happened after the proposal goes in, they're not going to look at it, except and this is a unique case where if the deal closes in a relatively short amount of time after the letter of intent, even though the deal might close after the proposal goes in, they can use the fact that the deal closed relatively quickly to confirm that the letter of intent was an agreement in principle. And I still can't get my head totally around that we're going to use something that happens at some undetermined point in the future to prove that the letter of intent that existed previously was a definitive agreement in principle. I just don't think you can do that. It may turn out to be a deal that goes through, but that doesn't, to me, make the letter of intent any more binding, any more of an agreement in principle. But it's just, you got to be careful with them, I guess, is the bottom line. And, this 1 month versus 8 months, that just comes from cases. There's no black letter rule there. In my case, it was roughly a month, and that was too soon. There's another case more recently where the letter of intent was signed, and then the deal didn't close for 8 months, and the judge looked at that and said, well, that has been too long, so there clearly was a lot more that had to be discussed, so we're not going to give present effect to that letter of intent. And, where it might fall in between 3 months, 4, there's no real guidepost there. Better to just make the letter of intent as non-binding and not definitive as you can, or maybe even consider not having it.
Right. Exactly. It seems like semantics sometimes, but in these cases, it sometimes matters. I know sometimes we've tried calling them indications of interest and instead of letters of intent. We've also explicitly said this indication of interest does not trigger 13 CFR 121-103D, this whole present effect rule. But again, it's like a lot of different factors. By just saying that, that's not going to be enough. If, for example, you have some of these other facts in play. So that's why we're trying to point out that it really can have a very serious effect, and it's important to try and implement some of these different things that we're saying now that you're aware of the present effect rule.
Yeah, and you do want to look at your timeline. Do I have an important proposal coming up that I got to make sure I'm small for, and I might be having some discussions with the party about a transaction, but maybe it's better in light of this upcoming proposal to slow things down on my transaction timeline. don't put a letter of intent in place, maybe delay the due diligence. We just got a question asking exactly that. Is it common to delay diligence and closing the transaction, et cetera, to accommodate these issues? And I don't know that it's necessarily common, but I would say it's recommended to be considering the impact of the transaction that you're considering and where you are on the transaction timeline against your upcoming proposal submissions and renewals and SAM recertifications, et cetera. That's really important. And we also got a question here, as long as I'm looking at the Q&A, what about earnouts? And I think that question was asked in the context of present effect. So an earnout, that wouldn't really come into play from a present effect standpoint, Kimmy, I don't think, right? Because the earnout is coming into play after you've closed the deal. So then there's no question we can judge whether the deal has an effect on your small business status, affiliation, et cetera, because it's already closed. What we're talking about under the present effect rule are agreements prior to actual closing that could, like a letter of intent, that could be considered an agreement in principle.
Mm-hmm. Okay, so I just looked at the time, we're getting close to the end of our time, so I just want to touch upon the third type of agreement covered in the present effect rule, which is convertible securities. So a convertible security can start out either as debt that's converted to stock, for example, or true ownership, or it could start out as a security such as preferred stock that later on, upon the occurrence of certain events, would then be converted to true equity or common stock. So, again, this is something like most commonly what I've run into here with small business government contractors is where when you're starting up, for example, and you need an influx of capital in the very beginning and someone is giving you money, making that investment, you promise that you'll give them like what's called a convertible debt or a convertible note, so that instead of when they give you the financing, that in the future you're explaining to them that in certain events occur in the future, then they will be able to convert that note into common stock and benefit by having true ownership in the future. Again, because of the present effect rule, however, and this is included as one of the three types of agreements where the SBA is going to look at it and view it as having already occurred, not waiting until that whatever the conversion trigger event is, but instead at the time when that convertible debt instrument or that convertible note instrument is put in place, that they're going to give that present effect. So even though this is a very common thing to do in getting seed financing or angel financing for startups, it can create problems for small business government contractors. The workarounds for convertible securities is very similar to the ones that we covered above about when you have stock options, same sort of problems, and therefore, like we were talking about, phantom stock or stock appreciation rights, those are the other kinds, or just even having it be done as debt, and that creating a contract or some sort of agreement where the investor will get a benefit later on if you sell the company, but not doing it as a convertible security type instrument, so that you don't trigger the possibility of the application of the present effect rule might be a better way to do that.
All right. So we landed right at 3 o'clock with our key takeaways. Be aware that the SBA may treat these things as if they've already occurred. Stock options, convertible securities, and agreements to merge or acquire. I mean, that's the main takeaway. Just know about this rule because it is, amongst the affiliation rules, one of the least common rules to come up, but it can definitely have major impacts on your corporate strategies. So if you don't structure the trigger points correctly, if you haven't thought through the timeline, the potential impacts, so make sure you do that when you're looking at giving stock options or convertible securities or debt and really analyze. I think it's worth sort of role playing through the scenario. If we're going to give stock options, or we're looking at giving a note that could be convertible into equity, or we're looking at an agreement to merge and talking about a transaction, game plan it through. If SBA gave this present effect, what would be the impact on our small business status or our eligibility for socioeconomic programs? And depending on the outcome, if you do that little mock audit at the outset, it can help you be best prepared to manage the effects of the rule going forward through the corporate strategies. So thanks everybody for participating. There were maybe a few questions we didn't get to answer during the webinar. Since we're out of time, we're going to stop here, but we will follow up with each of you by email. And anyone else that thinks of questions afterwards, feel free to contact either Kimmy or me. You see our email addresses popping up here on the screen. Like I said earlier, you'll all get a copy of the slides, so don't hesitate to reach out to either of us if we can be of assistance with these issues, or if you have questions. Thank you so much, and enjoy the rest of your day.